My name is Aaron Bowman with Compass Mediation CT. If you're considering divorce mediation, there's a good chance you're looking for something calmer than court. Less conflict, less cost, less damage. Mediation can offer that, but only when it's approached with the right expectation. Most mediation breakdowns don't happen because the process doesn't work. They happen because people unknowingly bring habits, assumptions, and pressure into the room that undermine it. Today, I want to walk you through the top 5 mistakes people make in divorce mediation here in Connecticut. Not to criticize, but to bring clarity. This isn't legal advice. It's an informational conversation meant to help you understand how mediation actually works, so you can decide whether it's the right first step for you. Mistake number 1, treating mediation like court. Mediation is not a courtroom with relaxed rules. When people bring litigation habits into mediation, arguing, posturing, or trying to score points, the process slows down and tensions rise. Court is designed to decide who is right. Mediation is designed to help people reach workable agreements. In Connecticut, mediation is often encouraged because negotiated outcomes tend to be more durable and less damaging. But that benefit disappears when mediation is treated as trial rehearsal. Clarity comes when people understand that mediation is about resolution and not verdicts. Now, mistake number 2, using mediation to vent emotions. Divorce carries emotional weight, and that can't be ignored. But mediation is not a space for emotional unloading. When sessions turn into outlets for anger or resentment, decision-making becomes nearly impossible. A mediator can acknowledge emotion without letting them dominate the process. The purpose of mediation is to address practical issues, finances, parenting, and future structure, not to resolve emotional history. When emotions are present but contained, mediation remains productive. Now, mistake number 3, arriving unprepared. Mediation works best when people come prepared with information, not assumptions. Many people assume mediation is informal and requires little preparation. In reality, lack of preparation leads to confusion, delay, and frustration. In Connecticut divorces, discussions often involve financial details, schedules, and long-term planning. When that information isn't available, progress stalls. Preparation doesn't mean knowing every answer. It means knowing what decisions need to be made and having the basic information to discuss them. Now, mistake number 4, expecting the mediator to decide. A mediator does not make rulings or impose outcomes. One of the most common misunderstandings is expecting the mediator to step in and declare what is fair. That does not happen in mediation. The mediator manages the process, not the results. Mediation remains voluntary and participant-driven. When people wait for the mediator to decide for them, frustration builds and momentum is lost. Clarity increases when parties understand that the responsibility for decision-making remains theirs. Now, mistake number 5, rushing for closure. Wanting the process to end quickly is understandable. Divorce is stressful, and many people push for a rapid resolution simply to escape discomfort. But rushing mediation often leads to agreements that are poorly thought through and are difficult to live with later. In Connecticut, mediated agreements often become part of the court judgment. That makes taking the time to understand decisions especially important. Moving deliberately is not delay. It is part of protecting long-term stability. Mediation is not about speed or winning. It's about clarity. When these 5 mistakes are avoided, mediation becomes calmer, more focused, and more effective. Understanding the process reduces fear and allows people to make decisions with intention rather than pressure. I'm Aaron, and I help Connecticut couples divorce with clarity.